The story, when it was first presented publicly, had the particular quality that distinguishes accounts that will be believed from accounts that will be questioned. It was not merely plausible, it was coherent in the specific sense that all of its components reinforced each other, that each element of the account found support in the others, that the whole was more persuasive than any individual part. It connected a person to a motive to an action to an outcome, and it did so along a line of reasoning that required no specialized knowledge to follow and no tolerance for ambiguity to accept. It was, in the vocabulary that investigators and prosecutors use to assess the communicative power of a theory of the case, a story that a jury could understand. That quality, the quality of being understandable, is not a minor consideration in the institutional processing of criminal cases. Trials are communicative events. They are proceedings in which complex evidentiary records must be translated into narratives accessible to people who have not spent months or years developing familiarity with the materials. The capacity of a prosecution theory to organize the available evidence into a form that non-specialist fact-finders can follow and evaluate is a genuine professional achievement, and it is, within the practice of criminal law, appropriately valued. The problem that this account traces is not that the story was clear, it is what the clarity cost, what it required to be set aside, simplified, or reframed in order to be achieved. The story had a beginning that established context, a middle that established conduct, and an end that established consequence. The beginning identified the defendant as a person whose circumstances, relationships, and history created a recognizable framework for the behavior that the prosecution alleged. It did not require the jury to imagine an inexplicable act by a person without discernible connection to the outcome. It required them to recognize a pattern, one that experience, both professional and ordinary, made familiar. People with reasons act on them. The story provided the reason. The middle of the story was where the evidence concentrated. The forensic findings, the witness accounts, the documentary record. Each was positioned within the narrative at the point where it did the most explanatory work. The forensic findings confirmed presence. The witness accounts established behavior inconsistent with innocence. The documentary record supplied the connective tissue between the person and the outcome. Individually, each element of the evidentiary record carried the qualifications and ambiguities that evidence always carries. Assembled within the narrative, those qualifications receded. What remained visible was the shape of the story, the arc from circumstance to act to consequence that the prosecution had constructed. The end required no elaboration. It was the outcome that the beginning had made comprehensible and the middle had made inevitable. Given the person, given the circumstances, given the evidence of conduct, this was where the story arrived. It arrived there not with the force of logical compulsion, but with the gentler force of narrative satisfaction, the sense that the ending fit, that the account was complete, that the question of what had happened had found its answer. The officials who presented the story did so with the confidence of people who had spent considerable time inside it. Investigators who had worked the case for months had organized their understanding of it around the narrative framework that the evidence, as they had assembled and interpreted it, supported. Prosecutors who had reviewed the file and prepared the charges had tested the story against their professional experience of what juries find credible and what they do not. By the time the story was presented publicly, in the charging documents, in the press statements that followed, in the preliminary court proceedings, it had been refined through multiple iterations of professional scrutiny and had emerged from that process more polished, more coherent, and more persuasive than it had been at the outset. The language in which officials described the case to public audiences was the language of common sense. The evidence, they indicated, pointed clearly. The conclusion, they suggested, was one that any reasonable person examining the facts would reach. There was nothing exotic or counterintuitive about what had happened. The case was, in the assessment of the people who had worked it, the kind of case that is difficult to investigate, but not difficult to understand once the investigation is complete. The facts were the facts. The story was the story the facts told. This framing, the presentation of a prosecution theory as the natural, inevitable reading of a factual record rather than as one possible interpretation of an ambiguous evidentiary landscape, is standard practice in the communication of criminal cases to public audiences. It is also, when the theory is sound, an accurate description of the relationship between evidence and conclusion. The difficulty arises in cases where the theory is not sound, where the coherence of the story reflects the skill of its construction rather than the completeness of its evidentiary foundation. In those cases, the language of common sense performs a concealing function. It makes the interpretive work that produced the narrative invisible, presenting as self-evident what is in fact the product of choices about which evidence to foreground, which to minimize, and which to leave outside the frame. Media coverage of the case in the period following the charge amplified the story's reach and reinforced its internal logic. Reporting drew on the official account, on the charging documents, on the statements of investigators and prosecutors who spoke with the authority of people who had examined the evidence directly. The story that emerged in coverage was recognizably the same story that the prosecution had developed, organized around the same causal sequence, populated by the same explanatory elements, moving toward the same conclusion. This is not a criticism of the coverage as such. Journalism covering criminal proceedings draws necessarily and appropriately on official sources. Those sources had produced a coherent account supported by a documented evidentiary record. The coverage reflected the account that the available authoritative sources provided. What it could not reflect, because the sources were not providing it, and because the documentary record that might have complicated the official account was not yet accessible to outside analysis, were the questions that the story had resolved by not fully engaging with them. The public reception of the story was, in this environment, largely uncritical, not because the public was credulous, but because the story that had been presented to them was genuinely coherent, genuinely supported by the evidence that had been made visible, and genuinely consistent with the explanatory frameworks that make human behavior comprehensible. It fit. It explained. It answered the question that the original event had opened. People who encountered it did not experience it as a narrative that required interrogation. They experienced it as an account that made sense. The comfort that explanation provides is not a trivial psychological phenomenon. Unexplained events, events whose causes remain open, whose responsible agents remain unidentified, whose meaning within the ordinary framework of comprehensible human action remains unclear, generate a form of cognitive and social dissonance that is genuinely costly. The story that resolved that dissonance in this case resolved it completely. It left no visible remainder. It accounted for the evidence, identified the responsible party, established the connection between person and outcome, and provided to everyone who received it the particular relief of a question answered. That relief was real. The story that produced it was persuasive, professionally constructed, and institutionally endorsed. It explained everything. And in explaining everything, in leaving no question open, no element unaccounted for, no loose thread visible above the surface, it had achieved the coherence that would make it, for a considerable time, effectively unchallengeable. The facts that complicated the story did not arrive dramatically. They did not present themselves as refutations, as evidence so clearly inconsistent with the established narrative that their presence demanded immediate reconsideration. They arrived as inconvenient facts typically do in the context of a proceeding that has already developed substantial institutional momentum, quietly and at the margins, in the footnotes of forensic reports, in the secondary details of witness accounts, in the documentary record that the defense had obtained through discovery, and was examining with the particular attention of counsel, looking for the points at which the prosecution's theory met its limits. Each fact, considered individually, was accessible as something less than decisive. This is the characteristic feature of the kind of evidentiary inconsistency that does not disrupt established narratives. Not that it is hidden, but that it is isolable. Each discrepant element can be addressed on its own terms, explained within the framework of the existing story, assigned to the category of peripheral detail rather than central evidence. The address is usually accurate as far as it goes. The individual fact usually can be explained without abandoning the narrative. What the individual explanation does not account for is the pattern, the cumulative implication of a set of facts that, taken together, suggest something more structurally significant than any one of them, addressed in isolation, reveals. The first category of discrepancy involved the forensic record. The physical evidence that had been central to the prosecution's account of events had been analyzed by the agency's designated laboratory, and the findings had been incorporated into the narrative at the points where they did the most explanatory work. What the defense's independent forensic review identified was not that the laboratory findings were false. It was that the findings were incomplete, that the analysis had addressed specific questions while leaving adjacent questions unexamined, and that the unexamined questions were ones whose answers would have been material to the narrative's coherence. The specific gaps in the forensic analysis were documented in the defense's expert submissions. They were presented to the court with the supporting technical detail that the applicable procedural rules require. The prosecution's response addressed them through a combination of technical rebuttal, challenging the methodology of the defense's expert analysis, and contextual argument, contending that the gaps identified did not affect the probative value of the findings that had been made. The court evaluated the competing submissions and ruled in terms that found the defense's concerns insufficiently established to warrant the relief requested. The ruling was within the range of reasonable judicial discretion. It was also a ruling that resolved the question of the forensic gaps for procedural purposes without resolving it in any deeper evidentiary sense. The gaps remained. They were now, however, gaps that had been addressed, that had a procedural history, a ruling, a place in the record as considered and decided matters. Their status had changed from open questions to closed ones, without the underlying evidentiary question having been answered. The second category involved witness accounts. The prosecution's narrative had been constructed in part on the basis of testimony from individuals whose accounts of relevant events supported the causal sequence the story required. The defense's examination of those accounts, both in cross-examination at trial and in the pre-trial review of the statements the witnesses had given to investigators, identified a set of internal inconsistencies and temporal impossibilities that the prosecution's narrative had not fully absorbed. Some of the inconsistencies were minor, the ordinary variation in recalled detail that characterizes witness memory and that courts routinely accommodate within a finding that the testimony is, in its essential respects, credible. Others were more substantial, accounts that placed events in sequences incompatible with the timeline the prosecution had established, descriptions of circumstances that did not align with the physical record, statements given to investigators in the early phase of the case that differed in ways that mattered to the narrative from the testimony given at trial. The prosecution addressed the more substantial inconsistencies through the standard mechanisms available for managing witness credibility, by contextualizing the variations within the acknowledged imprecision of human memory, by emphasizing the aspects of the testimony that were consistent across accounts, by directing the jury's attention to the corroborating evidence that supported the witness's essential claims, regardless of the peripheral variations. These are legitimate trial techniques. They reflect a genuine understanding of how memory works and how juries should be instructed to evaluate testimonial evidence. They are also techniques that, when applied to inconsistencies that are not merely peripheral, perform a reframing function, converting what might be assessed as structural problems with the evidentiary foundation into manageable variations within an otherwise sound account. The third category was perhaps the most consequential and the most quietly handled. It involved a set of documentary and circumstantial materials that the defense had identified as potentially pointing toward an alternative account of events. Materials that, if pursued, would have required the investigation to revisit lines of inquiry that had been assessed as insufficiently promising during the narrowing phase described in the preceding section. The prosecution's response to this category was the most procedurally aggressive of the three. The materials were challenged on admissibility grounds, on the basis of relevance, authenticity, and the applicable rules governing the introduction of evidence that points toward third-party culpability. Several were excluded. Those that were admitted were addressed in closing argument in terms that framed them as the kind of speculative alternative theory that defense counsel routinely constructs from available materials without the evidentiary foundation that would make the theory credible. The framing was effective. It drew on the psychological dynamic that the prosecution had correctly identified. That juries presented with a coherent account supported by substantial evidence are resistant to alternative theories that lack the same degree of evidentiary development. An alternative theory that has not been investigated has, by definition, not generated the body of supporting evidence that investigation produces. Its relative evidentiary thinness compared to the prosecution's developed case is partly a function of its not having received the investigative attention that would have developed it. But that distinction is not visible to a jury evaluating the two accounts as they appear at trial. The psychological investment in a good story, in an account that has already organized understanding, that has already been communicated to public audiences, that has already structured the professional work of the people who developed it, is not a trivial force. It operates through the entirely ordinary human tendency to find more compelling the evidence that confirms an existing framework, and to find more problematic the evidence that challenges it. This tendency does not require bad faith. It requires only the normal operation of cognition under conditions where a framework exists and the cost of revising it is high. For the institutions that had built the narrative and were now defending it in the adversarial arena of the trial, the cost of revision was not merely psychological, it was professional, institutional, and public. The story had been presented with authority. Its authors had staked their professional assessments on its accuracy. The agencies that had produced it had communicated it to oversight bodies and public audiences as the product of thorough and reliable investigative work. Revision was not simply an intellectual exercise. It was an institutional event with consequences that extended well beyond the evidentiary question it would have required engaging. The facts that didn't fit were in the record. They had been documented, argued, ruled upon, and in several instances admitted into evidence. They had not been hidden. They had been handled, addressed through the procedural and rhetorical mechanisms available to an institution defending a narrative in which it had significant investment. The handling had been sufficient to preserve the story's integrity through the trial. The story remained intact. The verdict confirmed it. The facts remained in the record, addressed but not resolved, handled but not answered. They sat there, patient, specific, and irreconcilable with the account that had just been certified as true, waiting for someone to return to them with a different question than the one the trial had been organized to answer. Narratives in the context of criminal proceedings are not decorative. They are not the rhetorical packaging applied to evidence after the evidentiary work is done. They are the framework within which evidence is selected, interpreted, and presented, the organizing structure that determines which facts become central, which become peripheral, and which are assessed as insufficiently consistent with the account to be incorporated at all. The story is not separate from the case. In important respects, the story is the case. It is the form in which the case exists for the institutions that process it, for the jury that evaluates it, and for the public that receives it. This is not a pathological condition. It is a feature of the way human cognition manages complexity. The evidentiary record in a serious criminal case is not self-interpreting. It is a mass of materials, forensic reports, witness statements, documentary evidence, expert analysis that requires organization before it can be evaluated. The narrative provides that organization. It answers the question that raw evidence cannot answer by itself, not what happened, but why, and by whom, and in what sequence, and with what significance. Without narrative, evidence is data. With narrative, it becomes an account, something that can be assessed, accepted, or rejected as an explanation of events. The problem this account traces is not that narrative exists in criminal proceedings. It is what happens when narrative becomes sufficiently consolidated, sufficiently institutionally embedded, sufficiently publicly communicated, sufficiently professionally invested, that the evidentiary relationship reverses. The story should be produced by the evidence. When the story has achieved a certain degree of institutional solidity, evidence begins to be produced for the story, selected, interpreted, and weighted according to its fit with the account that already exists, rather than according to its independent probative value. The process by which this reversal occurred in this case was neither sudden nor deliberate. It developed across the phases already described: the investigation that narrowed, the alternative leads that were deprioritized, the ambiguous evidence that was interpreted in the reading consistent with the hypothesis, the forensic gaps that were addressed procedurally without being resolved substantively. At each phase, the story had become slightly more consolidated, the investment in it slightly deeper, the cost of revising it slightly higher. By the time the case reached trial, the story had achieved a degree of institutional solidity that made it, for practical purposes, the evidentiary standard against which new information was being assessed. This inversion, from story as product of evidence to story as standard for evidence, is the mechanism by which narrative overrules truth in institutional settings. It does not require anyone to decide consciously that the story matters more than the facts. It requires only that the story be sufficiently established that the people processing the case are, without necessarily recognizing it, asking a different question than the one they believe they are asking. They believe they are asking, what does the evidence show? They are asking, how does this evidence relate to what we already know? The difference between those questions is, in many cases, inconsequential. when the story is accurate, when it reflects a genuine and adequately tested interpretation of a complete evidentiary record. Asking how new evidence relates to the existing account is functionally equivalent to asking what the evidence shows independently. The answers converge. The problem is that the process cannot, from the inside, distinguish the cases where the answers converge, because the story is accurate from the cases where they converge, because the process has been organized to produce convergence. The institutional preference for a single, stable explanation is not a preference that criminal justice systems would acknowledge as a value. Officially, the values are accuracy, fairness, and the protection of individual rights against the power of the state. Operationally, however, stability is a value that expresses itself through the incentive structures, the resource allocation decisions, and the professional norms that shape institutional behavior. A case with a stable, coherent narrative is easier to prosecute, easier to defend against appeal, easier to communicate to oversight bodies, and easier to close. The institutional rewards that flow to the people who develop stable, prosecutable narratives, the career recognition, the professional validation, the public acknowledgement of effective work, are real and consistent. The institutional costs of narrative instability, of cases that remain complex, that resist clean resolution, that require continued engagement with uncomfortable evidentiary complications, are equally real. Within this environment, the facts that didn't fit the story in this case were not suppressed. They were managed. The management was conducted through the ordinary institutional mechanisms available for handling evidentiary complications, procedural rulings, expert rebuttal, contextualizing argument, the application of admissibility standards that excluded some of the complicating material from the jury's consideration. Each mechanism was legitimate. Each was applied by people operating within their professional authority. The cumulative effect of their application was the systematic reduction of the evidentiary space available to the jury, the progressive narrowing of what the fact-finders were permitted to consider to a field that was substantially coextensive with the prosecution's narrative. The absence of a single villain in this account is not a rhetorical courtesy extended to the individuals involved. It is a structural observation about the nature of the failure. A villain narrative, the identification of a responsible individual whose deliberate wrongdoing explains the outcome, would actually be less troubling than what the record shows, because villain narratives are correctable by removing the villain. The failure documented here is not correctable in that way. It is a failure of collective agreement. The agreement, reached by no single decision and no single actor, to treat a narrative as more reliable than the evidence that was available to test it. The investigators who narrowed the inquiry agreed, professionally, that the evidence supported the narrowing. The prosecutors who developed the charge agreed that the case was prosecutable. The supervisors who reviewed the investigative and prosecutorial work agreed that the standards had been met. The court that ruled on the evidentiary challenges agreed that the defense's concerns did not meet the applicable legal thresholds. The jury that returned the verdict agreed, beyond reasonable doubt, that the prosecution's account was accurate. At each stage, the agreement was reached by people with the relevant authority and the relevant expertise, applying the standards appropriate to their function. The collective agreement was wrong. Not because any individual within it acted in bad faith, but because the process of reaching it had been shaped, at each stage, by a story that had become more important to the institutions processing it than the question of whether the story was true. Truth, in the context this account describes, lost not because it was opposed, but because it was inconvenient. The facts that complicated the narrative were not facts that any institution had decided to suppress. They were facts that required the narrative to be more complex, less coherent, less communicable to a lay jury, and less consistent with the institutional investment that had already been made in the existing account. They were facts that would have required the investigation to reopen lines of inquiry that had been closed. They were facts that would have required the prosecution to acknowledge that the story it had presented to the court was not the only account the evidence supported. These requirements were not impossible. They were costly, professionally, institutionally, temporally. And in the environment of a case that had been building toward resolution for the better part of 2 years, that had generated public and political attention requiring a visible outcome, that had organized the professional work of multiple agencies around a specific and coherent theory, the cost of the requirements that truth imposed was assessed, through the ordinary functioning of the institutions involved, as too high. The assessment was not announced. It was not made in any single document or any single conversation. It was the aggregate product of the decisions already described, each reasonable in isolation, collectively constituting a preference for the story over the facts the story had not fully absorbed. The miscarriage of justice that resulted was, in this sense, a product of institutional success rather than institutional failure in the ordinary meaning of that phrase. The institutions had done what institutions are designed to do. They had taken a complex and ambiguous evidentiary situation and resolved it into a clear, communicable, prosecutable account. They had produced a narrative that explained everything. They had defended it through the adversarial process. They had secured the verdict the narrative supported. What they had not done, what the process as it operated had not required them to do, was ensure that the narrative corresponded to what had actually occurred. That requirement had been present at the beginning, in the professional commitments and the institutional mandates of the people who opened the investigation. It had been progressively displaced, across the phases of the case, by the requirements of coherence, efficiency, and resolution. By the time the verdict was entered, the narrative had become the truth, not because it was accurate, but because the institutions that defined truth had agreed that it was. And that agreement, reached collectively in good faith through the ordinary functioning of a system designed to produce exactly this kind of agreement, was the mechanism by which an innocent person was convicted. Truth had not been defeated by malice. It had been defeated by the far more durable force of a good story, told with authority, at the moment when everyone needed it to be true. Stories do not collapse suddenly. The verb suggests a structural failure, a single moment of catastrophic disintegration in which what stood is no longer standing. That is not how narratives embedded in institutional records and public consciousness actually fail. They fail gradually, at the margins, in ways that are visible only to the people looking for them and invisible to everyone else. A forensic finding is reanalyzed and found to support a different interpretation than the one the prosecution relied upon. A witness account is compared against documentary evidence that was not available at trial and found to be incompatible with it. A line of inquiry that was closed during the investigation is reopened by someone outside the institutional machinery and produces findings that the original investigation did not pursue. None of these developments, individually, collapses the story. Each one loosens something, introduces a degree of play into a joint that the narrative had presented as solid. The loosening accumulates. It accumulates slowly, over years in most cases, because the mechanisms through which it occurs are not the mechanisms of the institutions that built the story. They are the mechanisms of the margins, the innocence organizations working through backlogs of post-conviction cases, the investigative journalists examining records that the trial coverage never reached, the academics studying patterns in wrongful conviction data who recognize in a specific case the features their research has identified as significant. These mechanisms are real and they function, but they function at a pace and with resources that are not commensurate with the institutional investment that produced the original finding. The delayed recognition of factual error in narrative-based wrongful convictions follows a pattern that is consistent enough across documented cases to constitute something close to a sequence. It begins with the identification by someone outside the prosecutorial and investigative institutions of a specific discrepancy, a single point at which the story and the available evidence do not align in the way the narrative requires. The discrepancy is documented and presented through whatever channel is available: a post-conviction petition, a published analysis, a formal complaint to an oversight body. The initial institutional response to this presentation is almost invariably framed in the language of procedural finality. The matter has been adjudicated. The issues raised were considered at trial or on appeal. The applicable standards for post-conviction relief have not been met. The response is not engagement with the discrepancy. It is a determination of the discrepancy's procedural status, its position in the sequence of available remedies, and a finding that its position does not entitle it to the substantive reconsideration it is requesting. This response is, in most cases, technically accurate. The standards for post-conviction relief are high, and deliberately so. The discrepancy identified at the margins of the narrative usually does not, in isolation, meet those standards. It is a loose joint, not a collapsed structure. The institution is not wrong that the standards have not been met. It is simply applying standards that were not designed to detect the specific category of failure that a narrative-based wrongful conviction represents, failure that resides not in any single discrepancy, but in the cumulative pattern that the discrepancies taken together reveal. The institutional resistance to rewriting the story is, at its deepest level, a resistance to the implications of rewriting it. A narrative that has been institutionally endorsed, publicly communicated, professionally invested in, and legally certified through the verdict process is not merely an account of events. It is a record of institutional judgment, a documented assertion by people with the authority to make such assertions that this is what happened. To rewrite the narrative is to rewrite the judgment. To acknowledge that the story was wrong is to acknowledge that the process that produced and certified it was, at some level, inadequate. The inadequacy need not have been the product of bad faith to carry institutional consequences. The organizations that investigated and prosecuted the case understood themselves to be acting competently and conscientiously. The record supports that self-understanding, in the sense that the specific decisions made were individually defensible. What the record also shows, to those who read it with the question of pattern rather than individual decision in mind, is that the aggregate of those defensible decisions produced a finding that the evidence did not fully support. Acknowledging that aggregate is a different kind of acknowledgement than identifying a specific error by a specific actor. It is an acknowledgement about the system itself, about the way the system, operating normally, produced an abnormal outcome. Systems resist that acknowledgement, not through deliberate concealment, but through the same dynamics that produced the original failure. The tendency to assess new information against the existing framework, the institutional incentive to confirm, rather than revise, the professional cost of the revision relative to the professional cost of maintaining the existing position. The story that the system built is also the story the system tells about itself. Rewriting one requires rewriting the other. For the person whose life was organized by the story, who entered the correctional system as the resolution of the narrative and remained there as its ongoing confirmation, the slow loosening of the story's joints is not experienced as progress. It is experienced as the continuation of a condition that has already consumed years, conducted through channels that are distant, slow, and calibrated to a standard of proof that the available evidence is always just short of meeting. Each procedural development, each petition filed, each ruling received, each determination that the applicable standards have not been met, extends the period during which the story remains the operative fact of existence. The psychological cost of this extension is not well captured by the clinical vocabulary of trauma, which tends to organize around acute events and their aftermath. What long-term wrongful imprisonment under a narrative-based conviction produces is something more chronic and more corrosive. The condition of living indefinitely inside an account of oneself and one's actions that one knows to be false, in an institution whose procedures confirm the account daily, in a legal and social environment that treats every challenge to the account as an obstacle to finality rather than a pursuit of accuracy. Identity under these conditions does not stabilize. It does not find an accommodation with the institutional account that permits a sustainable equilibrium. It persists in the gap between the account and the truth, maintaining, at increasing psychological cost, a private knowledge that has no public outlet, no institutional recognition, and no available mechanism for conversion into the kind of evidence that the system is prepared to act upon. The title of this account, A Story That Explained Everything, names both the mechanism of the failure and its cost. The story explained everything because it was designed to explain everything, because the institutional and cognitive processes that produced it were organized around the goal of comprehensive explanation, of the coherent account that leaves no visible remainder. What a story that explains everything cannot accommodate is a fact that the story does not contain. Such facts do not, within the story's logic, exist as evidence. They exist as complications, as challenges to coherence that the story's defenders are institutionally motivated to manage rather than integrate. The facts that were managed in this case did not disappear. They remained in the record, in the forensic reports, in the witness statements, in the documentary materials that the defense had identified and the court had addressed without fully resolving. They waited there, not as a coherent counter-narrative, not as a fully developed alternative account, but as the accumulated residue of a story that had been built to be complete and had, in the building, left things out. When the loosening eventually becomes visible, when the pattern of discrepancies accumulates to the point where the procedural vocabulary of finality can no longer contain it, what is revealed is not simply that the story was wrong. What is revealed is the process by which a story became more important than the truth it was supposed to represent. The institutions involved did not set out to convict an innocent person. They set out to explain what happened. They built an explanation. They defended it. They certified it. And in certifying it, they made it, for all practical institutional purposes, true. What remains after the story collapses, after the joints have loosened sufficiently, after the procedural barriers have been overcome, after the institutional acknowledgement has finally been made, is not resolution. It is an accounting of the years inside the story, of the relationships conducted across institutional distance, of the professional and social life that the story's requirements consumed, of the private knowledge maintained at cost across the full duration of the story's official truth. The story explained everything, It explained everything except what it had done. And the audience, confronted now with the gap between the story they accepted and the facts it could not contain, is invited to consider the stories they are currently accepting. The coherent accounts, institutionally endorsed and publicly communicated, that explain everything, leave no remainder, and have not yet been read carefully enough to find what they left out.